So we're going to talk about licensing today. There are three things that an inventor can basically do with an invention, and licensing is just one of the three. So for the general practitioner who has an inventor show up at his or her office, a lot of times the inventor will be questioning exactly what they can do to try to make money off their invention. Well, there are basically three ways that I've seen that people can do it. The first is they can make it and sell it themselves. The second is they can assign their patent rights to another company or to a person, as in they sell their patent rights. The third is a rental of their patent rights, which is a license. And so we're going to be covering the third of those, which is licensing your patent rights to another person. First, though, let's go over some of the advantages and disadvantages of the different means by which an inventor can try to make money off their invention. So the first is making it and selling it yourself. Now, to a lot of the inventors, when they first walk into your office, they're going to say, well, I want to make it and sell it myself because then I get complete control and I get to keep all the profit. That's true. If you are the person who makes it and you're in charge of selling it and finding the retail outlets, that's true. You indeed do get to decide everything. You get to keep all the profit. However, you also get all the headaches. So real briefly, if you want to make it and sell it yourself, let's go through the timeline here. You've got a product. You probably shop it over to China, find a factory there that either makes that product or something similar, and you find the factory that basically has the assembly lines all set up to make it. So you have to go over there, find the factory, get them all set up to manufacture. And by the way, they want to get paid up front, at least a third of the money before they start manufacturing. Once the products are finished, they're put in a container, usually a 20 or 40-foot container, thrown on a truck and taken across the border at Lo Wu into Hong Kong. Then they arrive at the freight forwarder. Now, the freight forwarder's job is to take the containers and put them on the right boats heading over to California. Or if you happen to only buy several pallets worth, their job is to get your pallets into a container that's going to Long Beach with similar objects that aren't going to crush yours. So once the freight forwarder has done his or her job, the products are in the boat and they're heading over to California. Now, back before the recent recession and the increase in gas prices, used to choose between fast boat and slow boat. Fast boat would generally make it from Hong Kong to Long Beach in 12, 13, 14 days. A slow boat generally would be about 3 weeks. Well, boats happen to operate like automobiles, which means that they operate most efficiently at partial speed, not full speed. So right now the fast boats are taking about 3 weeks. Slow boats can take over a month, which has caused a major change in the way that small inventors are doing business with China, in that somebody has to pay for all the time that product is sitting on a container ship going across the Pacific. And so anyway, it's not quite as efficient to get goods manufactured in China as it used to be because of all the time they're just sitting on the Pacific, traversing the route from Hong Kong to Long Beach. Now, once they get to Long Beach, they have to go through customs, and once they go through customs, some retailers like you to ship it directly in the container to their headquarters. They then break it down, throw it into other containers that go on trucks that go out to the retail locations. Others like you to break it down, in which case you, the inventor, have to have a warehouse, usually in El Segundo or Long Beach, and you have to handle that. You also have to be in charge of getting the product to a store, and you have to have found a store that wants your product. Once you get the product to the store, you have to deal with all sorts of the intricacies of dealing with retail outlets, such as packaging requirements. Is the barcode the right place, the right size? Are there the right number of inner cartons for a master carton? Are the right number of products for an inner carton? Did the products arrive on time? And so there are all sorts of kind of rigmarole regulations you have to go through. Otherwise, most of the larger retailers will fine you for failing to follow these. You have to deal with things like advertising allowances, product placement charges, and things like that. You also have to account for all the goods that are made, and so you want to compare the manufacturing records to the freight forwarder's records, to the customs records, to the retailer sales, and if 50,000 products disappeared somewhere there, you want to find out where they went. And there are a lot of unforeseen circumstances you also have to deal with when you're dealing with retailers. So if your inventor wants to make it himself or herself and sell it, great, all the power to them. They get complete control. They get to keep all the money that's left over. However, it's going to become more than a full-time job for one person. So the second route they can go, they can do an assignment of patent rights. Now, an assignment is basically a sale. And so you may say, you know, I own the patent to this 3-member nutcracker right here. I'll sell it to you for $500,000. Now, assignments are usually the second most desirable alternative to people who come into your office, because the idea of just selling patent rights and being done with it and just getting a big check is very desirable. The problem with that is that most inventors have a very twisted idea of how much their invention is worth versus how much somebody is going to buy the patent rights. So if somebody comes in with a patent on something and they say, I want $1 million for it, well, the prospective retailer is probably going to say, well, you've never sold one of these. How do I know it's going to work? I'm going to have to set up the factory. I'm going to have to do packaging. I'm going to have to market this. I can't give you more than $5,000 for it at this point. And so often with assignments, you have a huge disparity between what an inventor thinks the invention is worth and what a retailer or a manufacturer or a packaging company or anybody else who might want to buy the patent rights thinks it's worth. As a result, assignments usually don't go through very easily. And if they do go through at all, both sides are having to make major concessions. So the third alternative is licensing. And licensing is kind of both sides meet halfway. One of the attractive features of licensing is you can test market. It's kind of like trial dating before you have to marry somebody, in that you see how the relationship is going to work. You see if the person you're licensing your rights to can sell as many as they say, and the person who's going to be selling the products and manufacturing them, they get to kind of test the market, see if it's going to sell before they have to commit any serious money to the inventor. So anyway, licensing is often the third most attractive option to inventors, but it's often the one where they end up because they don't have the money to fund the whole thing themselves, and because they can't find anyone willing to pay them for the invention what they think it's worth.
But Eric, there's also some hybrid situation where you assign your patent, but in exchange of, let's say some down payment and some royalties, so that you would be associated with, the success of the product.
Yes.
So that it's not licensing, but it's close, because you are giving up the rights on the patents, the ownership, but you can still benefit from the success of the sales of the products.
Sure, and I think you'd have to compare that to a licensing situation where you're not giving up your patent rights. You still have them. You're just letting somebody else manufacture and sell the object. And I find perhaps with a sophisticated inventor, they'd be up for an arrangement such as the one that you're suggesting. I find with a lot of inventors, they're very paranoid about giving up what they see as their rights, because basically no matter how bad their invention is, they all think it's worth $1 million. And so they're just saying, I can't give up my patent rights for this. But yeah, with a sophisticated inventor, I think that would be a good
And
approach
sometimes it's
take.
Also a business model for non-practicing entity to come and say, oh, you have a very nice patent, let me help you. Give me the property of the patent. I'm going to pay all the fees, and
Sure.
It's also one of the things that is an advantage to license to assign is who pays for the fees for the US PTO and when you extend internationally. So the non-practicing entity would come and say, look, give me the patent and I would monetize it for you. You would I have strong arms and I can get lots of money because I'm a professional in the licensing.
Sure.
So that's also something that sometimes comes up of assigning the patent, but to get some return through the royalties.
And especially for a small inventor, often going to a company that's does this as a profession is a good route to go, because oftentimes an inventor will not be good at inventing, getting it made, doing the business end of things. They're better off finding somebody who can take over their invention partway through and trying to turn it into some dollars. Now, the other thing that goes on whenever you're dealing with assigning your rights and who pays the prosecution fees, what countries do you file in, I think you have to be very clear about who controls that and who pays for it, because obviously as an inventor, you don't want to leave all the decisions with your assignee, because they may say something, well, we want to file a surfboard patent in Mongolia, and you're the surfer and you're saying, no, it's never going to sell. And they're saying, well, I'm sorry, we're going to file it anyway, and by the way, we're taking that off of the net profits, so you're not going to get as much. So you want to maintain some control. At the same time, I think it behooves the inventor to approach such a relationship with the thought in mind that they're having to go to somebody to buy their rights because they don't have the money to do it themselves. So they may want to listen to the company and hopefully combine their knowledge to create a successful business.
Mm-hmm. And there are some certain situations where licensing is really your only option, like software.
Yeah.
If you invent something, you just can't, you're not going to necessarily assign each individual piece of code to the user. You have to license it. So sometimes, you say it's a third option. Sometimes it's the only option.
That's true.
That's true.
Yeah, if you're an average software developer, do you have the money to write the entire program, process it, do all the marketing? I mean, I think software licenses, they get on the average 7 to 11% or something like that. Do you want to take that and have Microsoft or Apple's clout behind marketing your product, or do you want to try to do it yourself on eBay? I'd rather take 1% of what Microsoft could do than try to hassle with selling it out of eBay and having the packages be in my garage. That'd be kind of a bummer.